The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good morning. We have 4 cases that will be submitted. Those cases are State of Iowa versus Andrew Russell, State of Iowa versus Zachary James, State of Iowa versus Betty Nall, State of Iowa versus Eddie Virgil. The last 3 cases are now submitted to the court without oral argument, and we'll hear the arguments in State versus Russell. Ms. Campbell.
Counsel. And may it please the court, Angela Campbell and John Sandy for the appellant, Andrew Russell. We are here on an interlocutory appeal from a motion that was called a motion to regulate discovery, but was really a motion, should have been called more accurately, a motion to limit the defendant's investigation. Russell submits that the granting of this motion by the district court violated not only the text of the rules, but the spirit of the rules, as well as several of his constitutional rights. And I think it's important to understand what this case is not about. The state and amicus have argued extensively that in filing these types of subpoena ducis tecum, that defense counsel is trying to bypass cash-in and the legislative intent of Iowa Code Section 622.10 to try to get psychiatric records of victims without the court or state involvement. That is not what this case is about. There is already a code section, there's already case law involving getting the communications that are privileged from a victim. This case is about issuing subpoena ducis tecum for other types of records, other types of non-privileged records that aren't protected by some sort of communication privilege, like with a psychiatrist or a physician. This is about things like cell phone records, cell phone location records, where a cell phone is at any particular time, perhaps Facebook records, employment records, timesheets, things that aren't privileged and aren't covered by some sort of federal statute or some sort of state constitutional decision and state legislative indication of how we're supposed to go about by getting that information.
When I read our subpoena statutes in 622, they always say you issue a subpoena either for giving a deposition or testimony or for bringing documents in connection with the deposition. I guess the basic question I have, where's the authority to issue a subpoena under the code without having it in connection with some testimony of some kind?
Well, first off, you can do it in the civil context. Granted, the criminal rules...
You can't do it in a civil context without a deposition or without a testimony. And when I threw that in practice, people used to do that all the time, and courts would stop that because the only authority for subpoenas in a civil area, again, is in connection with, now people may violate the rules, but the only authority is to bring it to a deposition or bring it to a trial. So, I mean, do we have to create a separate class of subpoenas, a non-statutory subpoena, that will allow you to just take subpoenas nilly-willy and get those documents?
First off, I would disagree that that's how the code section reads. This Iowa Civil Rule 1.1701 allows for issuance of subpoenas. Now, you can read them in congruence with each other to read that it has to be for a witness and also that witness has to bring those documents. But I would disagree that that's the case. And in fact, Cashin recognizes that that's not the case. They actually set forth how it happens with a privileged communication. It's not to a deposition. It's not to a court hearing. It's to the court itself. And they make an exception.
That was a judge-made rule. I mean, I'm asking you, do we need a judge-made rule in order to allow you to get a subpoena without having testimony?
We definitely need this court to intervene so that if the court agrees with the state that the code is not allowing it, then that switches into our constitutional argument that yes, we do need a judge-made rule then that says that a defense counsel can investigate these cases and get these documents.
Because Cashin has some constitutional underpinnings rather than following our rules, basically.
right? Just as any investigation would have constitutional underpinnings. There are,
Counsel, you began by arguing that the ruling below violated the text and spirit of the rules. Can you pinpoint what specific rule of criminal procedure or provision of the Iowa Code was violated?
I would submit, Your Honors, that Iowa Rules of Criminal Procedure 2.13 and 2.15 were violated. Now, I'm going to concede that these are not super clear on how this works, and that that's why we have this disagreement. The defense bar believes that the fact that depositions are set out in a different subsection as discovery and as a different subsection as subpoenas indicates that there are different ways that you go about getting information. You can do depositions if you want. You don't have to. And if you do depositions, you trigger the right for the state to depose your own witnesses. If you do discovery, you trigger the right for the state to get your discovery. But your investigation doesn't trigger anything for the state. I can investigate a case under this rule, is what I would say, without triggering some sort of reciprocal duty to provide information to the state.
You know, we read the rules as a whole, and I'm struck that Rule 2.5 sub 6 gives the state the opportunity to do these sort of private ex parte or, under seal pre-court proceeding subpoena duces tecum, but there's no counterpart to that for the defendants. Is this something that we should approach through rulemaking, or are you in effect asking us to read that into the rules?
I think both, Your Honor. I think that you can read it into the rule. Just the fact that the rules say that you're supposed to read these simply and with fairness in mind and judicial economy in mind, you can read into this rule that you're right, county attorneys can subpoena duces tecum before the charges are filed, and they don't have to give us that information unless it's exculpatory. In theory, they would have to give it to us, but they wouldn't know what's exculpatory in a pretrial investigation because they don't know what the defense is. But we have no ability to do the exact same thing, to get those exact same documents. We can ask them for them, some of them under the discovery rules, but we don't get everything under the discovery rules, and we should have the right to have an investigation for our clients. Now, I also think it would just make it much easier if you would also do rulemaking, but I think that there should be a ruling that sets forth this idea that there's a constitutional right to investigate a case, and that the state and this court and the Court of Appeals has said repeatedly there's no constitutional right to discovery. And I think that phrase simply needs to be corrected. There is a constitutional right to getting information about a case. Under the federal constitution and the state constitution, you have a right to inculpatory evidence because you get to have notice about what your charges are. You have a right to exculpatory evidence under Brady, and you have the right to have a counsel that will investigate your case and find out facts that are relevant under the Sixth Amendment.
But, I mean, we're not talking about what is normally considered investigation, but sort of this ex parte use of, or private use of the court's, of the subpoena power. And you've done a lot more criminal defense work than I ever did in practice. But, I mean, what you're proposing strikes me as very novel, and this notion that with a pending case, the defense lawyer can just get open-ended subpoenas for documents and just serve them for whatever they want. Has any jurisdiction anywhere adopted that?
The federal courts allow you to do ex parte subpoenas with court involvement.
Well, as I read it, yeah, first of all, there's court involvement, and secondly,
Correct.
you have to get a sort of case-by-case permission. You have to make a showing, right?
Right, which is what Mr. Russell's attorney tried to do in this, or was going to do in this case before he was cut off.
Well, what's wrong with that? What's wrong with saying, in general, the rule doesn't allow what you're asking for, but if you can make a specific showing that your client's constitutional rights are threatened without being able to get information, documents by subpoena, without the necessity of going through the process of having the witness show up, what's wrong with that?
I think there's two parts to that rule, and there's two parts to the consideration. The first is, if I want to just issue a subpoena duces tecum for regular documents, and I don't want to do it to a deposition, and I want to give them notice, Then they'll get a notice of the subpoena that I've issued under the rules like you would normally issue a subpoena. I send them a copy when it's served. Of course, the state doesn't always do that, but they're supposed to. Copy when it's served, I get the documents, I give them a copy. If I have something that I want ex parte, and I want to issue a subpoena ducis tecum ex parte, then I go to the court and I ask them for permission to do that ex parte. And I think the Constitution and the Sixth Amendment specifically should allow, and Article 1, Section 10, should allow for me to be able to do that in certain cases. And it shouldn't be a situation where I can't get any documents ever unless I have a deposition. And it shouldn't be a rule that there isn't some process by which I can ask for ex parte subpoena ducis tecum. And in this case, it was even worse. He can't do either. He can't ask for ex parte subpoenas, and he can't issue any subpoena ducis tecum for any documents. So my answer, I guess, is twofold. There can be a time when perhaps we just issue the subpoena ducis tecum, we follow the regular civil rule, which is where you give them the copy, and they get to see what it is, and it gets issued to the attorney's office. Perhaps the court thinks that's not the rule.
Well, the rule works that way, is you have a ducis tecum and you put in the notice, you can either produce the documents or appear for testimony.
Correct.
I mean, that's how you do it. It's not that you avoid the testimony part, but the documents are produced, you suspend the testimony. It's not just getting the documents. Maybe people shortcut it now, but that's not how the rule's designed.
Okay. I mean, then yes, a general practice is everyone shortcuts that. You don't subpoena the phone records to a deposition because you're not ready for them to come to the deposition until you've had a chance to look at the 1,000 pages of phone records. What you do is if you're following that rule, you issue a letter that says you don't have to come to whatever this hearing is if you provide the documents ahead of time. But again, that's misleading. What we're doing is we're misleading these businesses and we're misleading these witnesses by saying, if you just give me these records, you're free. Well, that's not the case. They might have to come later for a deposition. They might have to come for trial. We're just trying to get the documents so they don't have to fly here from California or Missouri, wherever the records are, to have them sit while we look through them at a deposition and then fly them back for a trial. It's just completely impractical and creates, frankly, a problem for defense
Yeah, but these
counsel.
rules and statutes are 50 years old. Their problem.
Yeah, they are written not anticipating the volume of digital discovery and written discovery that is coming up in these cases.
The way we do business now.
Correct. Yes.
All right, so are you content with having the court then as the gatekeeper to the issuance of these subpoenas?
Absolutely. That's who should be the gatekeeper. I mean, the state thinks they should be the gatekeeper, but it should be the court. If I issued a subpoena that was improper and the third party filed a motion to quash, everyone's going to know what I filed. Half the time if we issue a subpoena, they call the county attorney anyway. It's very rare that it remains secret. We should just have the opportunity to have that be that we don't tell the county attorney what we're doing, why we're doing it, and have a fight over whether or not we get to do it prior to issuing the subpoenas. It should be through the judge.
If you need to go before the court to determine whether or not effective assistance of counsel is going to require you to look at some documents in the hands of someone else, who's going to represent the interests of the counter argument that you shouldn't be entitled to look at those documents?
The whole point is
If it's ex parte.
they don't have a standing to make that argument. If I want to investigate a case and I want to look at the documents and they have the potential of being relevant and the potential of being exculpatory, I have the constitutional right for my client to be able to review that without discussing my strategy with the state. They have no standing for me issuing a subpoena to object to a third-party subpoena. That's the same in the civil context.
In Cashin, you had to go before the court before you can get it and say there's a reasonable likelihood. I can't remember the exact standard. I wrote it, but the legislature overruled it.
Right.
But you have to have
disagree.
some standard that the records will lead to exculpatory information. So you still have a gatekeeper function by the state, by the court, and you still have the state saying, no, they're not going to get there. So even in Cashin, the state's involved in that initial thing.
It's different in Cashin because Cashin's talking about privileged communications and talking about documents where you need a judge's signature to get them. You can't just issue a subpoena ducis tecum and get medical records. You can't issue a subpoena ducis tecum and get psychiatric records. And in fact, you can't issue a subpoena ducis tecum and get data records
But
from
I don't
electronic
understand your
communications.
procedure. You just file something, don't give it to the county attorney, talk to the judge, and the judge gives it or doesn't give it to you. That doesn't seem right.
Ex parte. If you want to do it ex parte, yes. If it's a subpoena for regular documents that's not protected and doesn't need a judicial signature, like cell phone location records, for example, you could issue if I want to give him notice and I don't want to go for the judge and I don't care about keeping it secret, then I can just do the regular standard that you would do in a civil practice, which is give them notice, I get the documents, I give them the documents. But if I want to do something that I don't want them to know about because I may be testing whether my client's telling me the truth, investigating whether what he's going to testify to is accurate, looking at whether their victims' information that they're providing is truthful, all of those things are something that I think should remain between the defendant and the client, and then the judicial branch in those circumstances. Thank you.
Ms. Campbell, thank you as well. Mr. Mullins.
Good morning. May it please the court. It's one thing to investigate. It's another to invoke the coercive power of the court. So let me start off where counsel did. Are we talking about non-privileged documents? Lawyers disagree over that all the time. On Friday, this court had to settle a dispute over whether morbidity and mortality privilege applied to some notes. So reasonable minds can disagree over the contours of the boundaries of zealous advocacy.
But the law requires a person who is holding claimed privileged information to assert that privilege. And if they don't assert the privilege could be lost. I mean, doctors assert it all the time because they say, I can't release it without a proper medical release under HIPAA. I mean, that happens all the time. So I don't see that as being harmed, because if a person gets a subpoena that's subject to some privilege, they're going to object to the subpoena or they're going to assert the privilege.
We'd like to think that they would. And it's not as though the state is asserting that it has a right to do anything more than press for the efficient administration of the judicial process, as the court had observed in Dahl. So, for example, it may be that the state has no particular standing as to the documents themselves, but we understand, particularly if we are talking about these non-privileged documents that are going to third parties, lay people, for example, it's relatively commonly going to be the case they'll see a command to appear and present, and either they'll think, all right, well, that satisfies my obligation, I've got this order, or B, that means I've got to hire an attorney to go deal with this, or I need to have the time for it.
But as I understand the subpoena form, the back of it has all these things on it about privileged information. You have a right to do this. It's not just appear. I mean, I remember we rewrote this. I was on that committee at the time. We rewrote the subpoena form to give all the safeguards to the people who received the subpoena. I mean, it's not like, come and show up. There's all kinds of procedures on the back, and it outlines it for them and gives them notice of their rights.
And what I'm saying is that the state has a limited and an appropriate position at the commencement of these actions to say, hang on a second, this may be overbroad. This may, despite its effort, actually involve privileged communications. It's a limited.
Won't that expose, potentially at least, in some cases, strategy of the defense? Let's say we have a criminal case where the defense does not want to engage in reciprocal discovery. It happens rather frequently. The defense has a witness that they think is pretty good, but they want to test, they're not sure, and so they want the phone records, say, of this witness. If you had knowledge of that, you would have an understanding of, at least somewhat, of what the defense lawyer is up to, would you not? And is that not a problem?
Well, but the specificity of your example undercuts the breadth of the argument that I think this court is faced with. Do you have a blanket rule that's going to apply in all circumstances, or do you have specific instances?
I guess I understand that. And it might be, conceivably you could say, well, if they want an ex parte subpoena, they have to go to the judge and they have to explain why they want to do it ex parte. And they tell the judge, you know, we've got this witness. We don't want to disclose it to the state. We're testing the witness out, et cetera. And the judge might say, okay, that's a basis for an ex parte order. What's wrong with that kind of arrangement?
And it's nothing fundamentally. It's just that that's ground that has already been plowed.
So you wouldn't object to, if as part of this case, we said, well, defense attorneys may seek an ex parte subpoena, an investigative subpoena, I'll characterize it as, where they make some kind of showing to the court ex parte that disclosure would impair their, or tend to disclose their strategy and undercut their right to counsel. You wouldn't object to that procedure?
Leaving aside my preference for a more orderly, not more orderly, because that sounds pejorative, and I don't mean that at all, but a rulemaking process could better develop a rule that might follow that. My point is that as courts have recognized that, say, for example, United States versus Nixon or Brady or Pennsylvania versus Ritchie or Davis versus Alaska, we've got this standard out there. There's this four-part showing that you need to make before you can get a subpoena ducis tecum for production of documents before trial for something more like an investigative purpose. And then if you wish to do so through an ex parte hearing, you're either going to have to show that you reveal something that the state is not entitled to see because it's incriminating and the state's not entitled to see it, or a third party is likely to destroy the documents. So presuming that the state's not going to be, alerting other people to destroy documents and engaging in that kind of misconduct, we're really only talking about that first part. And the Massachusetts Supreme Court has recognized, the bare assertion that I might reveal client confidences or work product or something like that, that's typically not adequate to establish the threshold basis for an ex parte hearing. So it's not as if, for example, counsel can't make a targeted showing. I want the phone records of my drug dealer, okay? So there's going to be some incriminating information there. But then you can say that. So it's not the blanket provision that under Rule 215 you can go and that the rule specifically authorizes you to get these ex parte.
Let me ask another hypothetical, and that is, sometimes these records are voluminous. And I haven't done the criminal work either with the same, certainly not anywhere near like the civil, but sometimes you get, 100 pages of documents, 200 pages of documents, phone records, employment records, that kind of thing. In a case where you don't do reciprocal discovery, to suggest that the only way to get those docs is to show up at trial and then have a big pile of documents, I mean, literally, it would be impossible for anybody to sort through those documents and figure out their relevance. How do we deal with that hypothetical?
Easily enough, okay? The point, and Massachusetts has explored this a little better than I certainly could. The point of pretrial production as use of a compulsory process, okay, use of the subpoena as compulsory process. The primary purpose of it is to facilitate the orderly administration of the trial. So sometimes if you think you're looking at voluminous records, the record holder is going to need time to compile this stuff. The attorney is going to need time to prepare it for presentation, okay? But the difference here is you're going to acquire a document that you're aware of. That's the point of compulsory process, and you have the power to acquire it and present it at trial. And you may need to do that somewhat in advance of trial for the orderly administration of things. That doesn't convert the right of compulsory process into an investigatory tool, which is basically what the majority rule has been. And it's for that reason that the courts have focused less on compulsory process and more on due process as a basis for fashioning a mechanism.
The state has the right to do this, and Justice Waterman pointed this out. I think it's important, the right to issue subpoenas in their investigation of the case, and you could read it either way. It seems like it's before the information's filed, but it doesn't really limit it to that point in time. But when you're a defendant, you really don't begin investigating the case until you're arrested. So you don't have all this pretrial stuff to do it, and you don't have a court forum until the information's filed or the grand jury indictment's filed, because there's no, quote, court number. So why not fashion a rule with giving the state certain safeguards that would give the defendant the same rights to do, quote, an investigation that the state has before it files its information?
And if we're working off of a blank slate, and speaking in general terms, my objections to that kind of a thing are fairly mute, or muted. I should clarify, however, that once a trial information has been filed, if a county attorney continues the investigation, they have to give notice and an opportunity for the defendant to participate in whatever is occurring there. So if we are talking about the time between arrest and the filing of the information, my suggestion is that, notwithstanding the state's ability to issue subpoenas, duce tecum, and then of course that information is going to be sealed, okay? We're not a whole lot different than other circumstances where, if you believe your client is going to be subject to a lawsuit or is going to be subject to prosecution, then you can send a litigation hold letter to those areas or to those individuals or companies that you think might have some information that you want them to preserve it, and then they should.
Part of the problem in our case here is when, in looking through the district court's order, and I think Ms. Campbell indicated this as well in her argument, is that it really prohibits any type of ex parte subpoenas at all under any circumstances. Is that the way you read this one, as opposed to our companion case, where it does allow for a somewhat of a procedure to get this information with court oversight? You see what the distinction that I'm making?
You ask a great deal of me to remember anything about any other case beside the one that I'm hearing for.
Well, and I apologize for that, but I'm just reading through the district court's order here, and do you agree that the district court here basically provided no, what I'll call, escape route or no means of doing it? It simply said you cannot and you're prohibited from issuing any subpoena except to secure a witness and do these things. It's a really broad, sweeping type of order in this case. Is that a problem?
I don't know how much of a problem it is. It does clarify and make the issue, ripeness isn't exactly the term, because as counsel's pointed out, we don't know what or if they're going to seek subpoenas. This could be a moot problem if in fact counsel believes that they're never going to issue a subpoena.
But in this case, it just says you can't do it. You're just prohibited from doing it. That's what's somewhat bothersome to me.
Okay.
And it doesn't allow for any type of, even an ex parte procedure, whether we did it as part of the case or by rule or however we come down on that. That seems to me to be a little bit of a problem.
I think there's a, well, for one thing, whether we characterize it as narrow or expansive, I think it does track the language of the rule, okay? And I think it does, I think that establishes, for one thing, that, there isn't much of a mechanism, if at all, and so there's no regulatory basis for what the defense would like to do. And so then we're necessarily tasked with solving these constitutional questions. But it's not like the system doesn't have a sufficient amount of flex. We know that you can seek an enlargement of a ruling, and so I would think that as much as the state has an interest in an orderly progression of a case, it wouldn't be out of line for counsel to reapproach the court, fashion a more targeted argument, and specify if it's going to be, with court involvement, that's one thing, and notice to the state, that's one thing, or if they're going to suggest that they need to do so without notice to the state, that might be another. My sense of things is that whether a district court is particularly hidebound is kind of an episodic circumstance. Sometimes we think they are, and sometimes we think they're not, and for the most part, I believe courts try to be as flexible as they
Your
can.
position, Mr. Mullins, that the rule supports what the court did, but you wouldn't foreclose if there was some constitutional imperative that would support an ex parte application for an ex parte or for a court supervised subpoena without the involvement of the state.
Yes, in short, but I have to make sure that I'm clear to the court that I think the constitutional bases for any particular procedure or avenue are relatively limited. They're important. They're, shall I say, narrow but piercing, okay, as opposed to sweeping and indiscriminate.
I'm not surprised you take that position, but I wonder what criteria you'd make that judgment. I mean, if you're a criminal defense attorney and you're doing all kinds of investigation, you're really diligent. You're gonna check out, and you've got all kinds of theories. Your client probably isn't gonna take the stand, but you've got all kinds of avenues to do, and just about all of a subpoena effort to get documents is gonna reveal strategy of counsel to some extent, isn't it?
And sometimes we expect attorneys to weigh the pros and cons of their actions. And
The price of a thorough investigation is to tell the state what your theory is.
not at all. It's a false choice. Because in any particular case, you may either be telling the state, you may be revealing nothing that isn't already new, or you're having to do the same thing, that make the same kind of a calculation that you would if you have a squishy alibi witness who won't talk to your
I
investigator.
mean, if you're testing the state's theory, I think that's probably right. I mean, for example, testimony say that a phone call was made on a certain date, and you subpoena the records to try and determine whether Verizon has the phone call. You know, I suppose the state has made the allegation, the defense counsel is looking into it, and, you know, maybe that's kind of harmless. But to the extent the defense counsel is exploring matters that are outside the scope of the minutes, testing out whatever they're testing out, I mean, half the stuff they won't even offer at trial, but is the state entitled to follow that thinking through non-ex parte investigative subpoenas? Saying yes, I think.
I'm not sure. And may I respond? The position that we're taking is that unless you're invoking the power of the court, your rights of an investigation are essentially protected through the statutory mechanisms that allow you to hire investigators.
Unless
It's
it,
once-
unless it infringes on right to counsel, and that's what we're arguing about, is when,
Okay.
when does that happen?
So then if you as a defense counsel wish to invoke the power of the courts, you may need to make some choices. How much of a risk do you wish to take that you might reveal something of your trial strategy? I dispute the notion that you always do. Now, if the court is concerned about these kinds of things, and we are working off of a blank page, which I disagree with, of course, and I suggest that there is a good mechanism for drafting that rule. In the abstract, I can have no difficulty with the idea that in order to protect a certain important constitutional provision, there ought to be some mechanism available for a defendant to protect those rights, okay? But I'm not suggesting that's available in all circumstances. And I think there are mechanisms and there are cases and there are procedures out there to allow a court to intelligently recognize and sift through this sort of thing. And not even in cases like Cashin or Dahl do we typically do so without notice to the opposing party, because the opposing party, irrespective of their motives, may be in a position to alert the court to something so that it doesn't make a mistake.
Thank you, Mr. Mullins.
Thank you.
Ms. Campbell.
Thank you, Your Honor. I'd like to address this idea that we can just take care of this in rulemaking. That does nothing for Mr. Russell, which is the case that we're up here on. There is no procedure in his case by which he can go and get an ex parte subpoena ducis tecum, or even a just regular subpoena ducis tecum.
Let me ask you a question. First of all, if you, in a case where you take depositions, the questions that you ask are going to reveal your strategy. Is it your position that you get to ask questions ex parte in depositions, which, by the way, you don't even get to take in the federal world, right?
Correct. Well, in the federal world, you can ask for permission to take them, but you don't get to take them as a matter of right.
I never got to take one. Maybe I guessing you have with your more extensive experience.
I mean, there's a process by which you can ask. It's very rare in the federal system. But we're not saying that there's a constitutional right to depositions. And sure, there are times when a motion to suppress will give away your strategy, that your listing of your insanity defense gives away your strategy, the listing of your alibi witnesses gives away your strategy. But I would disagree that every time when I take a deposition, I'm giving away my strategy, because in that deposition, a witness might say something that I or my client knows isn't true. And I can prove that if I can now subpoena those records to show that she just told something that wasn't true.
Why
in the
isn't the
deposition.
subpoena of the record the same as the witness? For example, you know there's a witness out there, you knock on the door, your investigator does, and says, we'd like to talk to you about X, Y, and Z transaction. The witness says, no, thank you. He closes the door. All right. Well, then you can end up ultimately doing a deposition, but when you do the deposition, the state, of course, will be present. So here we have a document instead of testimony, and so you call up Verizon or Google and say, we'd like this, that, the other thing, and of course they tell you no. Why isn't that the same as the witness who declines to cooperate?
And it is, and there's a federal statute that controls those two hypotheticals that requires when I send that court order signed by a judge, so I have to go to a judge to get it, to get a cable operator, which is now every provider with the exception of like 2 cell phones. So every cable operator which has data will give notice to the subscriber when I issue that subpoena. There's already processes by which I'm getting notice to other parties. And will that subpoena that I've issued end up in the state's hands? Perhaps. But it's not coming from me. It's not coming from me talking to my client in a privileged communication about what I'm investigating in this case. And that's the difference. Can they find it out? Maybe. And they could subpoena those documents themselves. They may already have subpoenaed them ex parte prior to the filing of the case. And maybe they haven't turned them over because they're impeachment evidence and they're not required to turn them over. Or maybe I haven't filed a motion for production of documents under a motion to produce because I'm not planning on doing reciprocal discovery. And maybe they already have all of it. And the problem that I have with the current ruling is that we lose every time. We lose the ability to investigate. We lose the ability to do a private investigation ever. We lose the ability to issue a subpoena for documents that might result in inculpatory evidence.
Don't you lose every time when the third-party witness declines to be interviewed?
It's not good for us necessarily, but we have a compulsory process to make them testify.
With the state being present.
That's true for the deposition, but there could be a time when you could have a request for an ex parte, I can't imagine one off the top of my head, where it's perhaps a doctor that's protesting it, and that's where Cashin is filling in the gaps there. But yeah, do I think that we should have more ability to investigate ex parte and more ability to command the cooperation of witnesses like the state does? Sure, but that's not how the system is set up. The system is set up already that the state has more power than the defendant. The state has police officers.
Yeah, but you keep going back to Cashin, and in Cashin, the state gets the records in the end.
Not necessarily. Well, in Cashin they did, but
Yeah.
now under the code section, no, what happens is it goes to the court. Court reads them all first, and then we both get them at the same time.
Yeah, but both parties get the records if they're gonna be admissible, so Cashin didn't keep anything secret from the state.
It did in that first set. It kept it secret from everybody, is what I'm saying. Like the code sections.
But eventually, before trial, the state got the records if they're gonna be used at
Correct.
trial.
And that would be true in a case, in this type of case too. I mean, I still have to give exhibits, except for impeachment exhibits, just like they do. If I'm gonna use the documents, I have to give them to them. If I'm gonna offer them and I'm gonna have a witness, I'm gonna have to tell them that at some point. They're going to get them if I use them. The problem is if I don't use them. And now they know my strategy, and they know a failed strategy. So they know, let's say my client says that he's at this particular place where there's a surveillance camera, and that's his alibi. And I subpoena that date and time of the alleged rape, and I get that camera, and he's not there. But I've already given it over, and now they know that the defendant has told me he was there, and that I've subpoenaed to find out if he's there. And that has given them information that they shouldn't have access to. That's the problem. It's not the problem when you want to use the documents, it's the problem when you don't. Thank you.
Ms. Campbell, thank you as well. The case of State versus Russell is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.